I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom, where law and culture meet.
It's really funny because the button says here, it says you're on 4, and actually you're on mic 5.
Oh, right.
So that is not mic 4. They've missed. Maybe they switched the mics.
Oh, am I speaking now live on the radio?
You're good. Your mic was like, I don't know.
You and I we're not having a conversation.
But now
are we, Mike?
No, now we're synergetic.
All right, perfect.
Yeah.
Well, as of now, I am on the radio. You are listening to Wade Beyond the Courtroom, and today we're going to be talking about Deflategate, negotiation tactics, and something in the law called plea bargaining. Because, Mike, this is where law and culture meet. Did you know that?
Yes, this is.
I put it the station in Waze today, which is a application that allows you to find a map to find where you're going, like Google Maps.
I like that.
And it actually said you're going to the radio station where law and culture meet. It was weird.
That is thus Wade Beyond the Courtroom.
That's right. We're ubiquitous.
I'm seeing how it's all coming together
That's
now.
right. That's right. So, are you familiar with before we talk about your shirt, Mike? Are you familiar with Deflategate?
No.
Okay. Well,
I'm not actually. I've heard it.
And I'm not familiar with one would get a shirt like that.
I've heard it says I'm on vacation.
That's right.
I've heard the buzzword, but explain.
Deflategate basically is, so there's this sports league called the National Football League. Have you heard of them?
Yes.
Otherwise known as the NFL.
Right.
I think they're kind of a big deal, right?
Kind of, yeah.
Okay, so last year there was this big scandal in one of the championship games in terms of that Tom Brady and the Patriots.
The footballs.
Correct.
Gotcha.
Yes.
Okay, yeah.
Thanks for coming in today, Mike. I appreciate that.
I mean, how soon we forget?
I know. So anyway, it was alleged, which is a legal word we can talk about, meaning not proven, that Tom Brady participated in the deflating of the footballs, which violates a rule. All right.
Yeah.
So the reason why that's important about what we're going to talk about today is Tom Brady just filed I he didn't do it. I don't think unless how good could the guy be? He's like a NFL quarterback. He's married to Jill Bündchen. And he's a lawyer. No, I don't think so. I think his lawyers did it for him. And anyway, so they filed this incredibly incendiary. That's my fault right there. We're off to a roaring start this morning. I don't know what's going on. He filed this incredibly incendiary motion in federal court, which basically called Goodell, which is the commissioner of the NFL, a complete moron, basically. Like that's legal talk for what he did. And the reason why we're going to kind of talk about that a little bit today is because basically the sides are now throwing firebombs at each other in federal court, and the whole world is seeing, the most popular quarterback, one of the most popular quarterbacks, and the NFL screaming at each other in court, right? And it's such bad optics. Everybody, Goodell looks bad. Brady looks bad, and we can go into why they're doing that in a second. But that all of this could have been avoided if perhaps they could have played like adults and done what's called a plea agreement or some kind of settlement.
Right.
And so what that basically is that if you're not aware, is that whenever there's a legal proceeding, either civil or criminal, okay, or there's a threatened legal proceeding, it can even happen before the courts get involved. The two arguing parties can enter into a plea agreement or a settlement. Settlement is typically for civil. Plea agreement typically is for criminal. So what we're going to talk about a little bit about today is why you would do that. So the Deflategate is a great example of why.
What would be his motive for doing that, though? I mean, come on.
Tom Brady?
Yeah.
Oh, easy. His legacy.
But he's a good ball player as it is.
Sure, but
so why would he need that advantage?
Well, because
is there advantage to have a football that's deflated?
Oh, I thought you were talking about why would he? Well, I am not an expert quarterback in the deflation of footballs. So maybe he likes to throw it that way, or it helps him get a better spiral. Or Warren Moon was on the radio and I was listening to him, and he said that he would be very concerned about his fingernails on his index finger and his middle finger, because if they were manicured properly, he could get a perfect spiral. These guys take it very seriously. They make millions and millions of dollars. So to him, maybe it was why he would do it would be for a competitive advantage. That's the only reason you would do it. You wouldn't do it for an aesthetic reason. I just like the way that they look. So that's the big argument. So he's saying that he's not saying necessarily that he didn't do it, right? I think he's falling back on that he didn't have any involvement in it, and no one can prove that he did anything wrong. Tom Brady sort of destroyed his phone before meeting with the NFL investigators, and I know as a criminal defense attorney, when you start seeing people destroying evidence, right?
Maybe he has an email server at his house.
Prosecutors generally like that when defendants destroy evidence, so that they can talk to the jury about that scenario. But yeah, no. So, but why would Tom Brady file all this incendiary stuff in court? Is because he's trying to protect his legacy.
Right.
So,
sure.
And now Roger Goodell's his ego is on the line. Brady's legacy is on the line, and there's incredibly high stakes.
Yes.
Right.
Yes.
Where all of this could have been avoided if they could have played like adults in terms of played nice with each other months and months and months ago and came to some kind of settlement. Whereas I think if the Goodell would have said, well, I'll fine you, right? You should have known that this was happening. I don't know for sure that you did. And we'll fine you for not participating correctly with the investigation. No games. And they don't even say anything about it. And it all would have gone away and nobody would be talking about it.
I think there's always going to be some kind of penalty.
Of course.
I mean, you don't just walk, okay, be careful next time. That never happens. Something always happens. You get suspended, or you got to pay a fine, or
but there's the image,
there's some
right?
penalty, right?
But what is the penalty, and what is the penalty for?
Right.
And that's when we come back from the break. We're going to talk about different types of pleas and something called nolo contendere, which is a Latin term. It's going to be very exciting to learn what that means when we come back. So you're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom. Welcome back, Santa Clarita. You're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom. So when we were talking before the break, we were talking about Deflategate.
Yes.
And it was funny. I like to spring surprises on you, Mike, and not tell you what we're talking about before I come in. So I saw you madly going on the computer and looking up.
It's just there's like so many scandals out there, and yet it's like it comes a wash after a while. It's like what? So I had to like connect the dots.
Right.
And I realized what it was.
Absolutely.
So again, we've determined during the break, and this is important research, that the regulation inflation on a football is 12.5 pounds.
Thank you for specifying which ball.
Yeah, the football.
Football,
right?
yeah. Soccer ball, different. Baseball, different.
Probably not looking those up.
Right,
That's another scandal.
So anyway, so the question we were having is, well, why would they not do some sort of settlement before this all started? And obviously, it's the optics. It's that's a fancy way of saying how things look to the public.
Right.
And the reason is that so Tom Brady wants to protect his legacy, because the Patriots had this whole thing where there was a problem a few years ago with Spygate, where they were allegedly or they were taping other teams' walkthroughs and stuff like that, which you can't do. So they have this whole stain of being a cheating organization on them by their detractors.
And I think that happens all the time, by the way.
Listen, the NFL, when there's that much money involved, they're all trying to break the rules, right? And like in baseball, there's the unwritten baseball rules that if you're, there's that saying, if you're not cheating, you're not trying, right? So there's this gray area. There's this gray area where people, they're trying to gain an advantage, but how much advantage can you gain? And are you breaking the real rules, or are you breaking kind of the spirit of the rules? So that's basically what Tom Brady is accused of doing. So he's worried about his legacy because he doesn't want to be branded a cheater when he goes in the Hall of Fame, and everyone's going to think of him that way, right? And Goodell is basically concerned about his legacy because he had that whole Ray Rice problem where he underpunished someone for this domestic violence scenario. That blew up in his face. He suspended the guy for a year, and so the NFL has all these issues. So he was wanting to come down as sort of like a disciplinarian. So those two things came together. But what they could have done, a way out of it, is, like I said, they both could have walked away okay, is that Goodell could have said, okay, here's what we're going to do. We're not going to say that you knew anything about it. We're just going to punish you for not participating in the investigation correctly. And then what's going to happen is that so that you don't have to admit guilt, right, Tom Brady, but we're going to fine you and then maybe take away a draft pick or something, but we're not going to suspend you any games, or you will suspend you one game. And then Tom Brady probably would have been okay with that because he would have gotten in trouble for like destroying his phone. He could always say, well, I never admitted to anything. And so this happens a lot in regular court cases, both civil and in criminal. So let's take a criminal example, right? So let's say that you get in a car wreck and you've been drinking too much and you get a DUI, right? I try to use crimes that normal people can get in trouble with that they think about, okay?
Yeah.
So thankfully, no one's hurt too bad. No one's hurt at all, okay? And but there's another car that's injured, right? So if you plead guilty to a DUI in court, the other person can sue you civilly and they can use that against you, that admission of guilt, right? So you can enter a plea of something that's called nolo contendere, also known as no contest, and the Latin translation is I do not wish to contend, basically just saying, look, I'm not going to fight the case. I'm going to let you find me guilty, but I'm not going to admit guilt. Now, in that specific situation that I told you, which is the car crash DUI part, if you do a no contest plea, then you can't get sued civilly and have that used against you. You're still going to get sued civilly,
right?
But the court case, the criminal case, is not going to hold that against you. The reason why that exists is it's the same sort of scenario as the Tom Brady Deflategate, is that it allows the parties to get what they want. Basically, there's a punishment, but it also allows the side that accepts the punishment to get some kind of benefit or advantage, right? So that otherwise, if you're just going to get punished the same, just go to trial. It doesn't really matter.
So you mentioned nolo contendere, but let's take, for example, the O.J. Simpson case where where a jury found him not guilty.
Right.
So the process was, took effect.
Right.
Yet the civil suit, there's still going to be a civil suit.
Right.
So why is that allowed?
That's different. Well, a couple things. One is that the standard of proof in civil law is different than the standard of proof in criminal law. So it's beyond a reasonable doubt in criminal law, and it's a preponderance in basically 51% in civil law, right? So, or depending on, I guess, what the suit is. But so the standard of proof is different. So the jury can still find him guilty of a wrongful death suit even though he had an acquittal in the criminal case, because there's two different cases, two different types of courts, and two different standards of proof. So even though it's talking about the same thing, so but that's not a plea. That's not a plea deal. He actually went to trial. So let's say that if O.J. Simpson would have pled guilty in a plea deal, which he never would have done, but let's say that he did, then they could use that against him in the civil case. So in the Deflategate scenario, or in the DUI scenario that we talked about, basically, is that you allow yourself to be found guilty, but for something else. Okay, and in that situation, then everybody walks home happy, and then you don't get into these giant scenarios where everyone's throwing firebombs at each other. Does that make sense?
Yes.
All right,
actually
perfect.
It does.
So when we come back from the break, we're going to talk a little bit more about negotiating tactics and how it's done in court. You're listening to AM 1220 KHTS. I'm attorney Wade Skalsky, and this is Wade Beyond the Courtroom. Welcome back. You're listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom. So we're talking about Latin today, nolo contendere. We talked a little bit about your shirt that it's great radio. It's a running joke every week. We talk about your shirt,
clothes, yeah.
which is really entertains only me, since I'm the only person that can see it.
This is actually Pierre Cardin.
It looks wonderful.
About 5 years old, too.
I know, right? I appreciate it. So I just don't like the fact that you look better than I do when you dress up to come to work.
You got the polo going on.
I know. It's all good. It's all good. So anyway, we're talking about negotiation tactics. We talked about Latin a little bit and nolo contendere. So in our scenario now, let's talk about what we do in terms of negotiating. So one thing that they could have done in this, let's talk about Deflategate for as an example. So I'm sure Tom Brady the entire time was like, if you don't do this, what I want, I'm going to sue you in federal court, which is exactly what he ended up doing. And so that's putting pressure on people in a negotiation, which is, if you don't sort of come to the table and do what I want you to do, I'm going to sue you. Okay, that's a common strong arm technique that people do. Well, that also exists in criminal law too. So we'll have a case, let's say, it's a DUI case, or let's say that it's a battery case or whatever, and you start the process, you get the reports and everything, and excuse me, the prosecutor says, okay, so I'm going to give you this deal, and if you don't take this deal now or the next court date, let's say within the next 30 days, I'm going to make it worse. And then so you're like, well, how can I make it worse? Well, the way that they're going to make it worse is they can add charges. Let's say that they always had the capability of kind of piling on more charges that they didn't put on before. And that is a tactic that the prosecutors use, because they're like, okay, we're going to put pressure on you because we just want this case to go away. Because if every single person went to trial in court, if all the defense attorneys got together, the public defenders, all the defense attorneys said, all right, here's what we're going to do. We're going to set every case for trial. It would paralyze the criminal justice system.
Oh, for sure.
Because 95% of cases basically dispose of through a settlement, through a plea agreement.
Right.
And so people have this perception that, defense attorneys, that all we're doing is going to trial all the time and, getting people off or getting them convicted or whatever. And that's just not true. It's most of the time it's a win for us if we can get the case either obviously dismissed or if we can get it reduced to something else. And that's where the negotiation tactics kind of come in. The prosecutors counter that by saying, well, if you don't take this plea here, we're going to add something else instead of not take it away.
Okay.
Are you with me on that?
Yes.
All right. So the other thing that then comes into play is, okay, so it's an adversarial system. There's this give and take. Let's talk criminal for a second, between the prosecutor and the defense attorney. So in that scenario, you have to use some tactics. So I'm going to reveal one of my biggest tactic ever in the world right now, so that for everyone to know. So if there are any prosecutors listening, they know to expect it.
You're revealing this.
It's a secret, right?
Wow.
So rule number one that I always have is don't negotiate against yourself. All right, and you hear people say that all the time, and people go, "What does that mean exactly?" And I'll give you an example. Some lawyers, they'll barge into court the first day of a case. Basically, they'll start shouting at the prosecutor and being like, "This is what I want, right? And you're going to give it to me because these are all the awesome things in my case." Okay, and they're very aggressive, and I always watch that and I always laugh. And the reason why I laugh, it's a secret, it's an inside laugh, really. I feel bad for their client, but the reason is because when they do that, they're basically negotiating against themselves. Because I've seen them do this without the prosecutor saying anything. So all the prosecutor has to do is look at all of the stuff that they present and just be like, no. Right? And then where do you go from there?
Right.
Okay. So what you have to do when you're negotiating is the first side that declares what it wants, basically, is going to set the tone of the entire prosecution and also of the negotiation.
Kind of a psychological thing too.
Well, yeah. I mean, look, if the prosecutor says, okay, well, we want, let's say 10 days in, let's just use jail for an example. We want 10 days in jail, right?
Right.
Or we want 6 months in jail, or we want 3 years in jail, or whatever. That's where the negotiation starts, because you need them to declare so you know what you're working off of. Because if I go in there and I say I want 1 day of jail for someone and they're going to want 5 years, that's going to be a non-starter. So why would I show them all the information of my case to try to get that 1 day of jail when I don't think the case is that serious, but they think the case is super serious.
Right.
So I need to know how serious they are about the case, and I have them declare first what's basically called an offer. What's your offer? Right? And I have them declare first. And so the reason then is then I try to work off of that offer using nothing, meaning, well, that seems just not specific facts of my case, but literally just by saying, well, that seems very harsh and he's a nice person and, it's a Friday or,
sure.
Stuff that has nothing to do with the case, right? And if you can, because you want to get them down without using all the good stuff. And then once you've got them down as far as you can, using all those collateral things that you may have, you then start talking about the case itself. Okay, because then you can maybe get them down even further because you're using the actual weaknesses of their case.
Right.
I don't understand why lawyers start with the weaknesses of the case first, because then once you go through all the weaknesses of the case, you have nothing left to bargain with or negotiate with.
It sounds, I mean, is there like a poker face kind of thing as well? I mean, as far as not knowing, like, oh my God, what card are they going to pull next?
Well, yeah, like the defense attorney typically knows more about the case than the prosecutor does, because the defense attorney gets to talk to the person that's actually accused of the crime. And so you have to have a poker face because you're not allowed to reveal things that your client tells you in attorney-client privilege,
sure.
Right? So in that scenario, a prosecutor may be saying something that you know is not true, but you can't say it because the only reason that you would know that that's not true is because you were told something in a privileged conversation. So you actually, I know this is like a serious topic. You have to actually be very, 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 very careful not to reveal information from those conversations. It's a big time problem if you do that.
Yeah.
So a poker face is important in that scenario for sure. And all these negotiations. This isn't a heavy hitting federal court, giant law firm in the NFL fighting negotiation tactic.
This isn't Wadegate.
That's right.
No, okay.
That's right. But I mean, these little things, you learn them over time, not to negotiate against yourself. That's just one example, and it's life is a negotiation. I mean, I'm married, you're married. I had to, it's a weird thing to say, but you have to basically agree with another person to spend the rest of your life together. And,
sure.
And that is, to get to that point, you have to kind of, dodge and weave a little bit as you two get to learn about each other, and that's a little bit of a negotiation, right? It's a little process.
Yeah.
Okay. Yeah. So but it was an interesting show today. We got off to a rough start. I mean, we're banging.
Well,
things.
you were throwing things down there, and I'm not quite sure. Then you started bagging on my shirt.
I wasn't bagging on your shirt. I was just commenting on it because you always have a different interesting shirt that you wear every week, and I feel
this is a radio shirt. Goes with the radio hair. It's part of the whole pack.
I have the radio hair, but I'm not confident enough yet for the radio shirt.
Yeah, definitely.
Right. So, but anyways, and so now we've all learned a little bit more about federal court and Tom Brady being mad at the commissioner of the NFL.
Yeah, nolo contendere, a pretty common thing.
Yeah, well, actually,
we know that, right?
Really quick before we go, is that some counties don't let you do a nolo plea.
Really?
So Orange County, there's judges down there that they won't let you do it.
Is it something that's like written in the books, or
they're just mean down there?
It's just choice.
It's a very conservative jurisdiction, and so
can you fight that?
No, you can go to trial.
Wow.
Yeah, you can go to trial if you'd like.
Yeah.
So, anyways, it's not a mean jurisdiction. They just have a different view of everything down there than we do in LA County. So
be it.
So be it, exactly. Well, look, Mike, a great show today. We started rough, but we sailed home very nicely. Yeah. You've been listening to your hometown station, AM 1220 KHTS. I am attorney Wade Skalsky, and this is Wade Beyond the Courtroom, where law and culture meet.